Breaking news from Washington, D.C. Today we have people outside of the Supreme Court ready to hear the decision on the Roe v. Wade case. This case will affect women everywhere in the choice to get an abortion. Now our newscasts are on the scene. Trent.
I'm here outside the courthouse ready to find out the decision of the court. Justice Blackman, what is your opinion?
Roe claimed that the Texas statutes were unconstitutionally vague and that they abridged her right of personal privacy, protected by the 1st, 4th, 5th, 9th, and 14th Amendments. By an amendment to her complaint, Roe purported to sue on behalf of herself and all other women similarly situated. John and Mary Doe, a married couple, filed a companion complaint to that of Roe. They also named the district attorney as defendant, claimed like constitutional deprivations, and sought declaratory and injunctive relief. This right of privacy, whether it be founded in the 14th Amendment's concept of personal liberty and restrictions upon state action, as we feel it is, or as the district court determined in the 9th Amendment's reservation of rights to the people, is broad enough to encompass a woman's decision whether or not to terminate her pregnancy. The detriment that the state would impose upon the pregnant woman by denying this choice altogether is apparent. Specific and direct harm, medically diagnosable even in early pregnancy, may be involved. Maternity or additional offspring may force upon the woman as distressful life in future. Psychological harm may be imminent. Mental and physical health may be taxed by childcare. There is also the distress for all concerned associated with the unwanted child, and there is the problem of bringing a child into a family already unable, psychologically and otherwise, to care for it. In other cases, as this one, the additional difficulties and continuing stigma of unknown motherhood may be involved. All these are factors that the woman and her responsible physician necessarily will consider in consolation. Now I'm just going to say.
Thank you, Justice Blackman. Now we're going to get the dissent opinion.
My opinion is there was no plaintiff in the case to whom the court's ruling could apply. In order for the court to rule that the states could not regulate abortion during the first trimester, it required the presence of the plaintiff to who, in her first trimester of pregnancy, at some point during the time her case was being tried, there was no evidence that the plaintiff, Jane Roe, had done so while in her first trimester. Thus, the court ruling had no application to the actual case before it. Another problem with the court's adoption of the compelling interest test, it would inevitably lead to judges acting as legislatures in an attempt to determine which state interests were compelling and which were not. The decision here to break pregnancy into 3 distinct terms and to outline the permissible restrictions the state may impose in each one, for example, partakes more of judicial legislation than it does of the determination of the intent of the drafters of the 14th Amendment. Moreover, the right of Blackman and the rest of the majority claimed to discover was apparently unknown to the framers of the 14th Amendment itself. There apparently was no question concerning the validity of this provision or any of the other state statutes when the 14th Amendment was adopted. The only conclusion possible from this history is that the drafters did not intend to have the 14th Amendment withdraw from the states that the power to legislate with respect to this matter.
Thank you, Justice. We have Miss Jane Roe and her lawyer coming out of the courtroom now. How do you think the case went?
I think it went very well. The choice of the baby should be in the right of the woman.
I feel like it should be every woman's choice whether they're ready or not ready for a child or not, and whether they feel that they're stable enough to have a child. It shouldn't just be life-threatening for the mother. The state impeded on her rights.
Thank you very much. Well, we have the dissent opinion. How do you think the case went for you?
I don't know. I mean, it just doesn't seem like the way it should be. I mean, Texas law, as we stated it, flat out says that you cannot have an abortion unless the mother's in danger. And in this case, the mother wasn't in danger at all. Everybody says it's a private factor, but it's a public factor. I mean, you're not going to have a round stomach and people asking where the baby is afterwards. I mean, it's just, I don't know. It's, like, I don't know. Like, I understand the amendment causes of this, but all in all, just give it a go. And a religion factor, even. I mean, I don't know.
Thank you.
Well, that's the end of our breaking news tonight. Let's go. Everyone can go back to their original programming.